It's Entertainment Law Update, episode 190 for April 2026. Well, hello, everybody, and welcome to Entertainment Law Update. This is April 2026. You know what April means, Tamara? It means it's our anniversary month.
Happy anniversary.
Happy anniversary. We are now 17 years old. We're in our 18th year of producing this show. Hard to believe. And
wow,
wonderful. It's been a terrific run and not ending anytime soon that I can see. So I'm really glad to be here. Anyway, thank you all for being here. Welcome to Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And this is our podcast by us, entertainment lawyers, where we talk about entertainment law and round up notable cases and news and information and those kinds of things. Try to keep you well informed and hopefully a little bit entertained with the show. And hey, before we start off, let's just say we do really welcome your feedback, suggestions, your input. So please visit entertainmentlawupdate.com, and there's a little voice widget there on the side of the screen, a little red tag that you can click to leave us a little voice message, or you can just send us email. The email address is entertainmentlawupdate@gmail.com. So, Tamara, you took a little vacation this last weekend. While I was in your neck of the woods, you were away.
I know you came to see me, or you didn't come just to see me. You came for work, and we're within 15 miles. And I was down to Georgetown, had a great weekend at the Two Step Inn 2-day music festival. Just so many wonderful acts, acts new to me, as well as acts that have been around for a long, long time. And a big hailstorm. So, that was fun outside.
Right.
My Boy Scout training did kick in, and that involved becoming the lowest point in the crowd. So we would not be struck by lightning.
Yeah, that would have been a cap on a weekend, wouldn't it?
It would have been. Yeah. That would have been to my knowledge, no one, it didn't strike right there at the festival grounds, but it was very close and nowhere to go. But we were prepared.
Yeah, good.
Yeah. And you know what? Unfortunately, it's not the first time I've been in a hailstorm. So outside.
Wow.
Thank you, Boy Scouts.
Well,
anyway, it was fun. How was Arlington?
I was in Arlington for the Military Creator Con, and I had a great time meeting up with a lot of great folks who have served or currently in service, a number of veterans there and so on, all of whom are transitioning or adding content creation and creator economy stuff to their repertoire of things that they do, and had a great time. I got to speak on the subject of becoming a modern media mogul, getting outside the hamster wheel of just create more content and sort of post and pray, and really being more systematic and disciplined about building a business with content as part of the engine that drives things. So really fun, really interesting group of people, and looking forward to being back again next year. So we'll be back in Arlington next spring, so I'll see you then.
Well, and you also shared in the wonderful weather, at least for one day of your visit. So that's what always happens.
Yeah, well, that was the day I was speaking. So I took the morning to sleep in a little bit and rehearse my presentation a couple of times. So by the time I actually came downstairs to the conference hall to do my thing and saw what the weather was actually doing, it was starting to brighten up already. But
well, good.
Yeah, it was a windy, rainy morning that day. So.
Yeah. Well, and it sounds like I need the show notes for your topic to implement myself. So.
Well, this may be a little bit.
We can talk about that later.
I was going to say, maybe a little bit of a do as I say, not as I do kind of.
Oh, okay.
Anyway, let's get into our stories for today. We'll start right off with a pretty significant jury verdict that came down last week, April 15th. A New York jury found that Live Nation and Ticketmaster were indeed acting as a monopoly. Now, we discussed the settlement with the DOJ last month, in our last episode, and the state attorneys general decided to continue the case forward. Well, this jury found that Live Nation and Ticketmaster is a monopoly, that it overcharges consumers by an average of $1.72 per ticket. I'm surprised it's only $1.72. There has been a Rule 50, a motion for a judgment as a matter of law to overturn that verdict. That has not yet been decided by the court. But the defendants in the case have stated in public, in releases, that they estimate the total damages figure at less than $150 million. That, of course, could be trebled in an antitrust case. So we'd be looking at about $450 million in damages. The judge is the one who actually decides the damage award. So still a bit of news to be made in this area. But let's talk about what the jury did conclude. First off, they said that Live Nation Ticketmaster is exercising monopoly power and in doing exclusionary conduct. And the jury said yes to both of those things. So they said Live Nation isn't just a concert promoter, but they also control the venues. And now through Ticketmaster, they also control ticketing. That is a vertical integrated monopoly in the eyes of the jury. And while that itself isn't illegal, companies do that all the time. The problem is that they used the structure to block out competitors from the marketplace. Things like pressuring venues to use Ticketmaster exclusively, tying access to tours to that ticketing relationship. So if you run a venue that doesn't use Ticketmaster, good luck getting those headline acts. And making it very hard for rival ticketing companies to get a foothold in the marketplace. That's where this really crosses the legal line. Now, the ticket prices were sort of front and center in the discussions about all of this. Yes, higher prices and fees are part of the story, but the legal nuance that matters really is, we don't punish companies just because they sell an expensive product. It really is punishing the harmful behavior, the things that hurts competition. So tickets costing too much isn't really the issue. It's tickets costing a lot because the competition has been squeezed out, and therefore there's no downward pressure on things. That's what the jury agreed was a violation of the antitrust law. Live Nation, of course, says no, artists are the ones that set the prices, and it is a competitive market, and the fees reflect real costs. They call that a business justification defense, but the jury just wasn't persuaded. They looked at this and said those justifications do not outweigh the anti-competitive effects of what they're doing. So we can expect more. There's that Rule 50 motion for the judgment as a matter of law. Long shot, but it's pretty standard. You'd expect a defense to raise that motion. And then it'll go up on appeal. It's where is that? That's the Second Circuit, I guess. So
yeah. And I think the ticket pricing issue has multiple problems. Mm-hmm. I mean, one, we've got this Live Nation Ticketmaster monopoly, but then we also have the ability of the bots and the legislation that's been pending over the years to try and stop, the technical scalping versus the good old days where people stood outside the door to sell you overpriced tickets. So I think it's multiple issues that are driving up the price of tickets. We went to, it's been a year ago, it was last April, a concert up at WinStar, which is a casino across the border in Oklahoma. Yeah. I don't think they're Ticketmaster. They're probably SeatGeek venue. I'm not sure. But we bought the tickets day of, very last minute. We paid an equal amount in fees to the ticket cost.
Wow.
So it was like the reseller dropped it down to $15 and we paid $15 in fees.
Wow. Well, okay.
So, I mean, I'm okay to get a $30 ticket, but
if it was $150 tickets that you're paying the same.
I don't know. It might have still been $15 in fees, but it's an interesting, and we just bought something else where the fees were astronomical.
Yeah.
So So I agree. The artists are setting the ticket price, like Garth Brooks on his last tour. He set his price at what I believe was enough for him to cover cost and was reasonable. But then the bots that went in and bought all the tickets
Yeah.
and resold them also drive up that price. So
Yeah.
I think it's an interesting conversation on multiple fronts.
Yeah, yeah. And, while the artists do set the ticket prices, they're, again, the fees and things on top of the ticket prices that are charged by Ticketmaster do add up to more. And, I think the jury was able to find that, well, what did they say? $1.72 per ticket. I'll take that as a discount.
Yeah, I'm waiting for my settlement
Get
to
your
come.
get your refund, right?
To get my refund.
We're going to keep watching the case because the appeals will happen, of course, and it'll really take shape there. But right now, the message from the jury is pretty clear. And, this is a defense that would have had a hard case to fight no matter what with a jury because, it's perception as much as anything. And not to say the jury was biased by their own experiences prior to the trial, but, there's a public relations spin on things that Ticketmaster Live Nation has had a challenge with, and it'll be interesting to see what happens. So we'll be watching for the ruling by the judge on the Rule 50 motion and the damages and remedies side of the case, which could even go so far as to break up the company, which, that's a pretty significant remedy. So we'll see. And then there will be the appeals. So we'll be talking about this next year too.
That's right.
That's my suspicion.
It's job security.
Yeah. So let's shift gears a little and talk about this. This isn't a case decision. It's a policy statement from the White House, basically. The White House released a new national AI legislative framework. And this is something we all in the entertainment industry really need to be paying attention to. Now, not law, not even a regulation. It's just a policy roadmap, basically a signal to Congress and regulators and the courts about how the administration thinks that AI should be handled. This policy is very pro-innovation, pro-AI, I guess you could say, and very cautious about how it approaches looking out for the creators on the creator side of things. The biggest unresolved legal question in AI right now is whether or not it is okay for AI companies to train their systems on copyrighted material without permission or payment. Books, music, scripts, images, all that raw material that we've been talking about now for years being sort of slurped up by the AI as training material. And this framework doesn't really help us answer that question. They have not come out with a direct response or policy view on this, not at least in a way that the creators are going to like. Respecting intellectual property rights and supporting creators. The theory here is that AI needs to be able to improve and innovate, and it has to be able to make fair use of what it learns from the world that it inhabits. That's kind of an interesting.
Which I was like, what in the world does that mean? So that was a bullet point, respecting intellectual property rights and supporting creators in this document.
Yeah.
But then they're using the term fair use, but I don't think they know what that really means. Anyway, sorry.
You're probably wrong. I mean, does anyone really?
Right. But, anytime we can get a Princess Bride hat tip in there, that's fine. Yeah. Nor do I understand what it means, what it learns from the world it inhabits. What in the world does that mean?
Right. Well, I mean, and the idea of inhabit suggests a living creature of some sort, right?
Well, or does it inhabit the world of the information it's been fed?
That's interesting. Yeah.
So
it's sort of an interesting dichotomy we've got going now because we've said it's not a living being, it's not an author for purposes of copyright because it's not human authorship, and yet on the other side of it, we're saying, well, it inhabits this world of authors' creations, and it has to be able to learn. I'm a little troubled by that.
Oh yeah.
Dichotomy that's going on there. The framework emphasizes, though, a few big themes that we're leaning on. One, let's keep the U.S. competitive globally, especially against China and the EU, which is interesting because the EU has come out with some pretty strong restriction on how AI operates. and some not so great also. And China is a little opaque on the subject. Let's avoid heavy-handed regulation that might slow down the development of the AI technology and the innovation. Okay, encourage voluntary standards and industry cooperation. I think I can get behind that. And focus on issues like safety and bias and transparency, all of which are important. But what's missing, really, is there's no strong stance on copyright and compensation for using training data, no clear rule about consent from creators, although that may have to come in those voluntary standards, and no framework for liability when the outputs from the AIs infringe.
Yeah.
I'm not sure we need a separate framework. I think if the output is infringing, we have remedies against whoever it is that's publishing those outputs, right? And maybe against the platforms as well. But this is where things are getting a little uncomfortable for those of us in this industry, right? We're in this sort of legal limbo. The AI companies are going to keep doing what they've been doing. Courts are still figuring it all out. There's still about 100 lawsuits going on that in the U.S. alone that address this. And for right now, the creators are sort of on the outside looking in, wondering how it's all going to shake out and hoping that there's an economy left when this all is sort of concluded. Yeah. So some folks have said, that this is the administration sort of dodging the copyright issue altogether, deliberately avoiding hard questions and leaving it to the courts, which I'm not sure is the wrong approach. But we have to wait a long time for the courts to do it. And this was an opportunity for the government to sort of at least give some guidance, act as a lighthouse on the dangerous points and sort of warn things off. So look, it's early in the game. We've got a long road to hoe on this, and we'll see what happens. Congress can step in when they're ready, let the courts develop the law first and so on. So what should we be doing right now? Well, nothing really got easier for us. You're going to see more litigation. You got to pay attention, right?
You've got to pay attention. I will also note that one of the bullet points in the framework was around preventing censorship and protecting free speech, which I think is encouraging.
Okay. Well, I mean, yeah, it's encouraging messaging. And honestly, that's right on point with what the administration has always been saying. Although I think there are those that would argue, myself included, that saying you're in favor of free speech and actually operating like you are two different things. And so what does that statement really mean, that bullet point? What is it's an ambiguous expression.
Right. I think it segues us into our NPR topic.
Yeah. Right on. You want to jump on it?
I will. So, defunding of NPR is unconstitutional. That's our headline here. The parties, National Public Radio, NPR, Public Broadcasting Service, PBS. I'm going to try and refer to everybody as NPR, if you don't mind. And then President Donald Trump is the defendant. President Trump issued an executive order 14290 in May of 2025 and instructed all federal agencies to end, quote, direct or indirect federal funding of NPR and PBS, specifically due to, quote, partisanship and left-wing propaganda, close quote. So he clearly stated why, and this is what's going to come back on this situation. Both entities or organizations were supported by the Corporation for Public Broadcasting, which was formed in 1967 pursuant to an act, and which it's now defunct due to the push by Trump to cease funding, again, because of the perception that the nonprofit entities were part of a liberal agenda. At the time, the Senate report stated that the intention of Congress was for local stations to determine for themselves what should or should not be broadcasted. This is back to 1967. And Trump made no secret that the effort to defund both of them was due to perceived biases. And part of this, various NPR affiliates had also sued the administration alongside PBS and their affiliates. This was deemed to be a naked, obvious attempt to punish NPR and PBS for their speech. NPR also sued CBP, which is a federal entity enforcing Trump's executive order. And on November of 2025, NPR and CBP had stipulated to dismissal as the executive order was unconstitutional. However, the matters were consolidated this year, and then we have the dissolution of the CBP. And the disagreement really centers around whether the government, and specifically the president, has the ability to decide which speech to fund, and when choosing not to fund, penalizes disfavored private speech. So the defendant's stance is the government is free to consider the content and viewpoint of the speech that it subsidizes, and the executive order is constitutional because it merely chooses not to fund plaintiffs with taxpayer dollars. The plaintiffs, NPR, PBS, state when the government provides resources or support to facilitate private speech, the government may not deny federal funding or any other benefit to a speaker in retaliation for conveying a message the government dislikes. And I think that's the key.
Yeah.
The court first addressed if the matter was applicable, was it moot? And it said it is to CBP. Because they dissolved, but it is not moot as to the president. Was it a ripe question? Yes. To the extent the federal government is arguing that the harm is uncertain because they haven't applied for any funding yet, the court was disinclined to dismiss standing or declined for non-discriminatory discriminatory reasons. And the court went on to say, yes, there's viewpoint discrimination. NPR understood that the executive order put it on notice. It needed to change its journalism and editorial choices if it wanted to receive those fundings. So there was a chilling effect when the executive order was issued, as well as the order made no effort to define or regulate the content of government speech or ensure compliance with the federal program. It did not set a neutral or germane criteria to apply to all applicants for federal grant programs. It singles out two speakers and bars them from those federal funds. They went ahead on to look at the First Amendment, prohibiting the government from leveraging funding decisions to suppress or compel speech based on viewpoint. And that federal funding is not an entitlement. The government may not deny funding in a manner that infringes upon constitutionally protected freedoms. And the unconstitutional conditions doctrine holds that the government may not deny a benefit to a person based on that it infringes his constitutionally protected speech. And there's Supreme Court decisions supporting that. The court rejected the argument that the executive order was merely an exercise of executive discretion over federal funding. While the president does have some power in that area, it far exceeded that. So the executive order is unconstitutional because it constitutes viewpoint discrimination in violation of the First Amendment. The government cannot penalize or restrict funding to entities based on a disagreement with their speech, and it cannot coerce changes in editorial content as a condition of receiving those public funds. So where does that leave us? Are they going to start receiving those funds again? I mean, I don't know what the step is the next step is. I mean, obviously it's been ruled unconstitutional.
Well, we did have the big, beautiful bill pass, and that, did not include any funding for that would have been in the previous bills. So I think it would take an act of Congress to restore funding to, at all. So, we'll have to see how Congress acts and what happens, both later in this term and after the election in the fall. The midterms may have a big influence on the outcome of this. Interestingly, though, I just want to point out that there is such a thing as the government speech doctrine. And that basically says that when the government is making the speech or when the speech is occurring on government platform, government property, those kind of things. I'm thinking about like schools and things like that. The government does have discretion to decide what speech it will permit and what it won't. It's when it sort of has either taken a hands-off approach historically or things are set up so that it's private speech. In this case, it sounds like the court ruled that this was not government speech. The money being spent was just allocated, but to support a private entity or private entities. I think that may be something that comes up on appeal. I don't know if it was raised in the initial pleadings or not. But I think that's a significant thing. When the government is paying for something, that doesn't necessarily make it government action, right? Or I should say funding.
Oh, yeah. And I mean, I guess the other side of that coin of what you're talking about is government funding to universities, public universities.
Yeah.
And so it's a big thing in Texas that the public universities are telling the professors, you can't read that book anymore. You can't add this to you have to take this out of your syllabus. Because these are things for which we're going to lose our public funding.
I think this is going to be the area that the First Amendment jurisprudence really looks at for the next, few years at least.
Yeah.
Not to mention, the separation of church and state stuff as well, that I think is going to be pretty significant. Anyway, something we'll be watching. It'll be interesting to see what happens. Does the Corporation for Public Broadcasting rise from the dead and resurrect itself? Because that was how the funding was channeled to NPR and PBS, was through this governmental nonprofit organization that now has shut down. So I had forgotten.
So who's producing Sesame Street now?
The Children's Television Workshop is the producer of Sesame Street, and they are a separate private nonprofit that received some of its funding from CPB and some directly from the PBS stations. And now I believe that first of all, yes, Sesame Street is no longer carried on PBS. I believe it's on, I want to say Netflix, but it might have been Disney Channel took it on. So it is now distributed through one of the major streamers and not the traditional PBS.
It's no longer
I don't know whether that came about because of the threat to government funding or what, but my understanding is that Sesame Street is still alive and kicking. So,
I'm not the target. I don't have anyone in the target audience anymore, but I do have very visual memories as a child seeing the Corporation for Public Broadcasting logo and brand. Okay, this is crazy. Maybe this was a foretelling.
Yeah.
Well, yeah, because if it came out and if it, I don't know when Sesame Street started, but 67, we were the first generation. In that, oh gosh.
I had a really interesting experience. When I was about 18, I was working at a theater and there was a kids play that came through the theater, and I was talking to the director and sort of creative director of this show, and he asked me a whole bunch of questions. How old are you? What do you do? And getting really into things. And when I asked him, why are you asking me all these questions? He said, well, because I was the creator of Sesame Street. And so, I just wondered, did you watch Sesame Street as a kid? And we got to talking, and he was one of the creators, I should say. And it was a fascinating conversation that I wish I had a little more knowledge and insight back then, so I could have asked better questions of him. It is what it is. Anyway, so we'll be watching what happens with this. I suspect that we won't see much changing until, there's probably some appeals to be made, and also when we have a new Congress, what happens under that framework. So anyway.
Yeah, we'll see.
What happened with Taylor Swift? Oh, go ahead. Sorry.
Oh, no, I was just saying fond memories of all that fun stuff we watched as kids on PBS. Yeah, so Taylor Swift, the showgirl she is and the life she's leading, while most of the time we don't discuss recently filed cases, we thought this was an excellent public service announcement on branding and trademark protection that our audience would appreciate. Taylor Swift, if you don't know, I can't explain,
Pretty much the biggest name in pop music these days.
Yeah, the biggest name in pop music. Is battling trademark protection for her brand Life of a Showgirl, which is also the title of her recent record. And she's battling this on multiple fronts, both in federal court and at the U.S. Patent and Trademark Office. Her entity filed a trademark application with the USPTO on August 11, 25 for the mark Life of a Showgirl. This was filed in multiple classes for a magnitude of goods and services. I mean, hundreds per class, probably. The application was examined and a non-final refusal issued, asserting a likelihood of confusion with actually two marks. One being Confession of a Showgirl, owned by Marion Flagg, and the second is a prior filed pending application just for Showgirl for perfume. That's not part of our conversation today, but because that application was pending, Swift's team decided to not respond to any of the refusal and just say, please suspend our application until you make a decision on what's happening with that Showgirl mark. I think that's a good move because they know it's not going to go forward until something happens there, and they don't necessarily show their hand on their arguments. But Marion Flagg, she didn't wait for the USPTO. So on March 30th, 26, she sued Swift, her entity, her record label, and her merchandise company for trademark infringement, stating she'd been using the brand Confessions of a Showgirl since July of 2014. She does have a trademark registration for the mark for her entertainment and educational services. She has online publications, magazines, e-zines, and she does put on a live stage production and theatrical show under the name Confessions of a Showgirl, and that seems to kind of be her pseudonym as well. So that's recently filed. We don't have really an update on the case, but what I think is interesting is Swift's team for trademark protection. Her original trademark application was filed in Jamaica on May 15th. And the U.S. application filed, I believe I said in August of last year, is based on both use in commerce as well as this foreign registration. And filing a trademark application in a foreign jurisdiction is often a tactic to keep a new brand on the down low prior to the product launch. So Swift filed in 15 different classes of goods and services, including Class 09, which is for musical sound recordings. While the title of a single creative work is not protected by trademark law, a title used on a series of creative works is eligible for trademark protection. And then obviously she has planned on and is using the mark on many items as a mark and for trademark branding. Here's my estimation of what's going to happen is that there's going to be a settlement. Miss Flagg will continue to use Confessions of a Showgirl. I think I think the Swift team will agree to let her keep her registration, and they'll come up with some kind of agreement to get the Taylor Swift registrations through at the PTO, whether that's some kind of coexistence agreement, some kind of carve out. I don't know. I don't think they'll respond and do a full argument, especially in light of a current lawsuit.
Well, I'm wondering because, when you say that we'll let her continue,
let them. Yeah, that's meaning they're the big Goliath.
The registrant. So unless they've got grounds for some cancellation proceeding or something like that, I don't think there's a lot of leverage there other than just the pure economic leverage of we can fight this longer than you can. So
I'm thinking the economic leverage is money that's going to be paid to her because it's right. She does have it first. I believe she's able to prove use in commerce. I don't think there would be a reason to cancel the mark.
Right.
I think it's just going to be a settlement between the parties.
And there is an argument that there are differences, the different perceptions of life of and confessions of. I think that could be argued both ways in front of a judge or a jury if it came to that. But I think you're right. The economics don't make it worthwhile.
I mean, kudos to her for saying this is...
Hold up.
Yeah, hang on. I've got an issue here, and so did the examiner at the PTO. And it doesn't mean that Goliath should be able to take me down. I agree. I mean, I think I could argue both ways for Class 41 entertainment services. Could a consumer be confused? Now, the Showgirl pending application is only for Class 4, or the Showgirl registration is only in Class 4. Both are for perfume. So Swift's application is only refused on the basis of her class 4 in
Yeah.
relationship to this other mark. So I'm wondering, what if they had filed individual applications?
I was just
Instead of
gonna
filing
say.
one application, they
Mhm.
had filed 14, 15, 16, ever how many it
Yeah.
was. Would that have only slowed down class 41? Probably not, because class 25 and class 9 are typically related.
Mhm.
But I don't know. Would it have slowed down the other classes? Clearly not class 4. They didn't think perfume was related. So
I'm surprised
I
that
don't
they
know.
didn't at least register in keep class 4 out. If they did a search, they would have found Showgirl for sure. And
Well, I'm
why
sure
not?
they did a search and saw
Yeah.
confessions of a showgirl and showgirl. Well, I think because they can argue there's enough difference
Yeah. Yeah. But again, why
with
not
even though
file
they both have.
those in those classes where there are competitive marks separately so that the other apps can at least have a chance of moving forward in the event of a suspension because of a conflict in one particular class? It's a strategic decision the lawyers made, and
Right, and it costs a whole lot more to do
that's
that.
true.
Um,
I think Taylor can afford it.
I think, yeah, she probably can. But for your small client, for many of our
Yeah.
clients, I mean, I would be hard pressed to think of any that
Hmm.
I think it makes up. I mean, maybe your client does need to file in 15 different classes,
Well, or at least
but
2 or 3. If you see that there's a possible conflict over here, let's carve that one out and get this other thing
right.
through if we can.
Eh,
But yeah, we for those of our clients that aren't made of unlimited money, we have to triage the expense of the application process and the prosecution. So,
Right.
it is the way of the world, I'm afraid.
Yeah, so we'll watch it. We'll see if I'm just wrong,
No, I think you're probably on the right
and
track.
and what happens.
Yeah.
And I think it's a good practice tip if you're trying to keep it under wraps. Look at which foreign territories make sense to file in to get your priority.
Hmm.
Then file your application in the U.S. within 6 months so that
Yeah.
you can claim that priority. And
Yeah.
that
Yeah.
might help you through.
Indeed. Well, next up, another trademark related issue. Let's talk about Pepperdine University's case against Netflix. You may remember that the Christian University in Malibu, California, has teams called the Waves, and they sued Netflix and Warner Brothers Entertainment and some other entities over a TV series that runs on Netflix called Running Point. The show centers on a fictional professional basketball team called the Los Angeles Waves. Pepperdine said the use of the name Waves closely mirrored its own athletics nickname, and that the show went further by using a similar blue and orange color scheme for the fictional team. Stylized wave imagery, references to the number 37, which is the university's founding year. According to Pepperdine, all of this pervasive use of branding created an implied association with the university. And they expressed a lot of concern about the show's adult themes. Remember, it's a Christian-oriented affiliated university, the Church of England, I believe. And, the show has adult language, sexual content, drug use, alcohol, all of those the university perceived as potentially damaging its Christian institutional reputation. So Pepperdine sought a temporary restraining order to block the release of the series. That was denied. They claimed they wanted injunctive relief prohibiting use of the branding. They wanted monetary damages for trademark infringement and related claims. They asserted claims for trademark infringement, false designation of origin, dilution, unfair competition, and the defendants, as expected, responded by arguing that the series is a protected expressive work under the First Amendment. They maintained that the show is a creative TV production, not a commercial product. They're not using the trademark as a source identifier, and the use of the waves is an artistically relevant bit of expression in the context of this fictional sports narrative.
Right.
They relied pretty heavily on the framework set up in Rogers versus Grimaldi, which we talk about frequently here on the show, which limits trademark liability for expressive works unless the use of the mark has no artistic relevance and there's no artistic relevance or explicitly misleads consumers as to source endorsement. The defendants argued there's no likelihood of confusion. The show is clearly identified as coming from Netflix and Warner Brothers right from the outset. Opening titles, you see that. So it's unreasonable that to think that any viewer would believe that Pepperdine had anything to do with or endorsed the series. So the district court here in the Central District of California ruled on the 12B6 motion for failure to state a claim. That early TRO request had been denied previously. The show was released as scheduled. So the judge, in this case, Judge Cynthia Valenzuela, granted the motion, the 12B6 motion, dismissed all trademark claims. Looking at the Jack Daniels case, for example, concluding that the Netflix shows did not use the mark as a designation of source for their own product, the Running Point show. And they turned to Rogers versus Grimaldi and said, the Rogers test applies. It's an expressive work. And they found that the term waves had artistic relevance to the fictional team and couldn't give rise to liability unless it was explicitly misleading. They determined no, not explicitly deceptive, and it wasn't used as a trademark in the legal sense. It's functioning as a series or a source identifier for the series. Rather than functioning as a source identifier for the series, it was used as a story element within the fictional world of the show. So even though it appeared frequently, it didn't serve to identify the origin of the series to viewers. So, failed to show that it was used as an identifier for the series, instead demonstrated it was part of the internal identity, so dismissed all counts. I don't know if Pepperdine has... I'm sorry, it was a 12B6 motion, so the plaintiff was granted leave to amend. So we may see more out of this before it's all said and done.
We might, and this is where I just interject that for this case and the case we're about to discuss, my colleague and I, Jordan Hendricks and I, pre-recorded our segment that's broadcasting today for CLE.
Oh.
And we discussed both of these cases
Good.
3 weeks ago.
Okay.
So we don't have this update in that CLE.
Okay.
So if anybody goes to My Law CLE and watches that on the recording, or I think they're missing it probably today. I think it's already on.
Well, that'll be available.
I'm sorry.
As a recording.
It'll be available. It'll be available, and you can.
MyLawCLE.com.
Yeah, you can listen to our CLE, and the behind the scenes. That our segment was pre-recorded, and that's why we don't have this latest update on this decision and the Bored Ape decision that we're going to talk about now. So we've talked about Bored Ape, a bunch of times, and the NFTs, non-fungible tokens. This is a dispute between Yuga Labs and Ryder Ripps and his collaborator, Jeremy Cahan. We talked about it in episode 183, but I feel like we've talked about it a few other times too. The case arose when Ripps, an artist critical of Yuga Labs, accused the company's Bored Ape Yacht Club collection of incorporating alt-right symbolism and offensive imagery, and to protest and comment. Ripps and Cahan created and sold a competing set of NFTs that used the exact same images from Bored Ape. They framed the project as satire, challenging Yuga's branding and broader premise of NFTs by demonstrating that supposedly non-fungible digital assets could be duplicated and resold. They created an ape market where their NFTs appeared alongside users. I would say further confusing the consumer. Yuga sued, asserted trademark infringement and related claims. As we've talked about before, one decision the court made in there was that an NFT can't function as a trademark. But of course, the defendants put up their defenses saying NFTs are not goods, not eligible for trademark, but as I just said, that was struck down. They also argued nominative fair use and expressive speech under the First Amendment. Those also failed. And the court looked at and applied the Jack Daniels property versus VIP products decision, which we also just talked about in the Running Point case. And in this instant, they were using the brand as a source identifier. But that led to once that question is answered, then they apply these trademark infringement questions, which that circuit applies sleek craft and the likelihood of confusion factors. The court did find a mixed record. Um, they said Yuga's marks were strong and the products were closely related, but other factors such as different marketing channels, the sophistication of an NFT buyer, I question that, and ambiguity around actual consumer did prevent a clear ruling in Yuga's favor. As a result, the appellate court concluded that infringement had not been proven as a matter of law, meaning the case could not be resolved on a summary judgment motion and needed to proceed to the fact finder. So it was kicked it back to the jury after there was confirmation that an NFT could function as a trademark and you needed to apply Jack Daniels. So April 2026, rather than having trial, the parties settled. Under the agreement, Rips and Cahan accepted a permanent injunction prohibiting them from using Yuga's trademarks and imagery. So that pretty much shut down their NFTs. Most of the terms were not public, but the resolution secures Yoga's control over its IP and closes down this set of litigation. And I think there was some good case law that came out of this. I mean, we have a clear understanding now that NFTs can function as a trademark. We have a building body of case law applying Jack Daniels properties first, determining if a mark is used as a mark. And then going on to apply either sleek craft or DuPont, depending in what jurisdiction you're in.
Was there any like Rogers style defense pled at any stage of I mean, I guess if you got to the Jack Daniels, you were sort of getting into that question.
Well, so this case started before Jack Daniels properties.
Right.
So yes, the defendants were going through that Rogers type of scenario. But when it started working through these next stages, the courts applied Jack Daniels and said it's a source identifier.
Yeah, because I mean, it sounds like it could be both an NFT. I mean, an NFT could be both a brand and an artistic expression. And the defendants in this case originally said, look, this thing is a parody. It's meant to comment on that original. And so that's why I wondered if Rogers had been a factor.
Yeah, but I also think if they were they really commenting on the original when they copied the whole work? I think that's
where's the commentary? Right.
Yeah, where's the commentary if you copy the whole work? So anyway, to post Jack Daniels decisions on fair use and third-party trademarks.
Yeah. Well, our next case deals with also trademark brand kinds of stuff, dealing in this case with some online sales. The case is Liu versus Monthly out of the Seventh Circuit just a few weeks ago. The dispute arose between Yini Liu, a trademark owner engaged in enforcement efforts against counterfeiters, and a large number of foreign online vendors, China-based e-commerce sellers, and so on, who operated digital storefronts on platforms like Walmart.com and eBay. These defendants were all sued under a Schedule A, I guess this was case, Liu versus Monthly, the litigation model that allows plaintiffs to proceed against numerous unidentified sellers in a single action. So Liu files this sweeping trademark infringement lawsuit in the Northern District of Illinois against hundreds of these online sellers, alleging that the defendants were selling counterfeit goods bearing her registered trademark and operating storefronts accessible to consumers throughout the United States and offering to ship those goods to customers, including residents of Illinois. The complaint didn't individually identify the defendants beyond their inclusion in this Schedule A list, and none of the defendants initially appeared in the case. So, relying largely on screenshots of online product listings and checkout pages and so on, she sought and obtained default judgments against all of them. She asserted claims for trademark infringement under the Lanham Act, contending that these defendants were engaged in the sale and distribution of counterfeit goods into the U.S. and had purposely directed their commercial activities toward Illinois and U.S. consumers through the use of these e-commerce platforms. After the default judgment is entered, several defendants appeared and moved to vacate the judgment, arguing that the court lacked personal jurisdiction over them because they didn't have sufficient contacts with the state of Illinois. They also challenged personal, service of process and so on. Central to their position is the claim that there was no evidence of any actual completed sales into Illinois, only a theoretical possibility that the goods could be shipped there. So the Northern District rejected these arguments and upheld the default judgment, concluding that personal jurisdiction was proper. They reasoned that the defendants operated interactive online stores accessible in Illinois. The listings indicated their ability to ship products to Illinois, and the screenshots showed potential sales to Illinois customers. And so the court denied the motion to vacate, so it goes up on appeal. There, the central issue in front of the Seventh Circuit was whether the district court lacked personal jurisdiction over these foreign online sellers and rendered the default judgment void, and ultimately whether the evidence showing only website accessibility and shipping capability without proof of actual completed sales was sufficient to establish jurisdiction. The defendants argued that the record contained no evidence of actual transactions with Illinois and contended that the default was void. So the Seventh Circuit agreed with the defendants and vacated the default judgment. They remanded the case with instructions to dismiss for lack of personal jurisdiction. The court emphasized there was no evidence in the record of completed sales to Illinois customers. The screenshots only showed potential. They didn't demonstrate that any transactions had actually been consumed, and that was a critical factual error underlying the district court's determination on jurisdiction. They further looked at whether accessibility alone is sufficient and concluded no, based on some prior decisions. Advanced Tactical Ordnance Systems versus Real Action Paintball and Curry versus Revolution Labs. And they reaffirmed that mere operation of an interactive website, even if it's capable of shipping products to a foreign state, isn't purposeful availment unless there's also evidence of actual sales or other targeted conduct. So these precedents really underscore that interactivity alone is not enough for jurisdiction. So they said, look, a default judgment can't cure these jurisdictional defects, therefore remand and dismiss. So
we got a couple of practice pointers in that one.
You think?
You get your sister to make a buy. You get somebody who's not in your law firm that will be fine on the stand.
Yeah.
To make a buy.
Mm-hmm.
Not to say I use my sister every time for that, but
And your sister's name and address is?
Yeah. No.
No, you're right. You have to find. Well, I mean, in analyzing this, go file the case in a state where someone did purchase. I mean, that's the other option.
Right, because you would have jurisdiction there. I mean, even though that's not where the plaintiff is located, it would be where the defendant is located. And I'm looking at the order, and it says we vacate the default judgment, and remand with instructions to dismiss the case against the defendants for want of jurisdiction. But it does not say dismiss with prejudice. So I don't know if that is...
Could they refile in another state?
Or if they make a buy and then refile in the state they're in.
Oh, that's interesting. Yeah.
So I don't know. Would it say dismiss with prejudice if that's... would it be that specific?
A determination for the trial court to make is should it be dismissed with prejudice? What are the criteria?
Okay.
But that's an interesting question. Yeah, I mean, so a practice pointer is choose your jurisdiction carefully. I think this does sort of reopen questions about the scope of what international shoe is meant to do in this modern age of online selling. I think, I mean, is my recollection from some of the case law from almost 35 years ago in law school was that advertising in a jurisdiction was considered a minimum contact if it was directed at the jurisdiction. But running a website that can be accessed from anywhere, if you don't do something to actually draw viewers from a particular state, That's a good question. What, if their keyword advertising somewhere said, Chicago residents buy here or something like that.
Yeah.
That might have been a different story.
You would know it's targeted.
Yeah. So, and it's
I would just say, well, yeah. I mean, and there's Walmart on every corner, so
Right.
I don't think Walmart is, but it is the foreign entities and the foreign shippers. I mean, I love it on Amazon when you're like, oh, I'm going to return this, and they're like, it's in China, just keep it. But my practice pointer would be, you need to be making buys of anything, purchases of anything that you're going to want to file for trademark or copyright infringement.
I find myself wondering, would there be a case against Walmart.com and eBay.com or Amazon if it was in Amazon? I know Amazon has its brand registry protection system that you can use as a trademark owner to get them to take down infringing counterfeit kind of goods. I don't know if those other platforms do the same, and if they don't, then could they be liable for essentially trafficking in counterfeit goods?
Oh, that's interesting. I'm going to ask some clients about that because as you go on Walmart.com or the Walmart app, I mean, it's clear they're selling you a bunch of stuff that's not at Walmart.
Yeah.
I mean, you can buy all kinds of things that they're just doing a fulfillment for somebody else.
Section 230 immunity for that.
Okay.
But maybe not. I mean,
or maybe they have a DMCA claim. I mean, for the copyright part of it, they would have if there's images involved.
Or text, I mean, it's interesting. I'm sure the lawyers on the plaintiff's side in this case did look at all of that a little bit.
And
it's possible that those other entities were already dismissed out of the case sooner. I didn't go back and look at the original pleadings. So, interesting to explore, but it is what it is for where we are now. Or maybe, so I don't know if this came out, and maybe it did, and it just didn't get into the facts at the district court. Yeah. Maybe they couldn't get it shipped. Oh.
I mean, maybe they attempted and it didn't happen.
That's interesting.
Now, if I was the defense counsel, I would have vetted all that in a deposition. Yeah. But again, we don't know. Those are just the facts. We don't know.
Well, we have another case. Let's move on.
Okay, sorry.
No, it's just, we're getting up on an hour, and I want us to finish our
That's show. Right.
So this is the case of ASTM International versus Upcodes Inc. And the plaintiff in the case is the American Society for Testing and Materials. That is ATSM International. They are a nonprofit organization that publishes technical standards for industries, and legislatures typically incorporate these standards into statutes and regulations, sometimes incorporating them by reference. So ASTM funds its operations by selling and licensing the standards individually or under subscriptions. We've all been there. We've seen this. Standards are reviewed on a 5-year schedule and either reapproved, revised, or withdrawn. The defendant in this case, Upcodes Inc., is an online research platform that offers searchable databases of building codes. They use a freemium business model where users can view and copy the building codes and standards for free, while they have other things that are behind a paywall, like the function of bookmarking or annotating and automating and some AI tools and things like that. So April 2024, Upcode starts publishing ASTM standards on its website without a license because in numerous jurisdictions, like the city of Philadelphia, have included the standards as part of their building code as governing law. Philadelphia, for example, adopted the 2018 version of the International Building Code as its governing law, and that was then ASTM had published updated versions after 2018, and that's what Upcodes displays. So ASTM sues Upcodes for copyright and trademark infringement, and then moved for a preliminary injunction to restrict posting of copyrighted standards on the website. Trademark claims were not at issue in this particular case, and the Upcodes, they won on a likelihood of prevailing on the issue of fair use. So the trial court says, no, it looks like it could be fair use. You've got a chance of winning. No injunction. So ASTM appeals, and here we are. on the fair use analysis, the court takes a look and uses the Warhol analysis. There needs to be a justification of the use that supports the need to make the copy. You have to copy the song lyric in order to parody the song. That's the sort of the hypothetical example. Under that Warhol analysis, it said that yes, it's transformative because the function or purpose of the upcode's use changes the original work. No actual changes needed to be transformative. I'm not sure about that. The court said the district court correctly called it transformative pursuant to another DC District Court decision. I'm sorry, DC Circuit decision, ASTM versus publicresource.org, where Public Resource had posted standards online, and it was found to be fair use to copy those standards because it served a different purpose than the plaintiff's work, creating best practices compared to simply providing the public with a comprehensive repository of the law. Okay, maybe. Upcodes was deemed to be doing the exact same thing as Public Resource in those cases. So the appeals court stated the nature of Upcode's use was largely non-commercial, despite the fact that they had commercial components on the website, because it didn't charge for copies of this material, but for additional features that was in line with the analysis and weighed in favor of fair use. Nature of the work, also in support of fair use, the court said the works constituted technical standards, and ASTM's works, when incorporated into law, were so factual that it leaned in favor of fair use. On amount and substantiality of the portion used, the court argued that all the copying was justified, even though it copied the substantiality of the works at issue. The IBC being made law through reference with the Philadelphia example, and given that there were internal references within the standards, it pretty much was essential to copy the whole thing in order to make it useful and functional. And the court references how this relates back to the first factor and transformativeness. And here it says Q Tamaro discussion regarding transformativeness and analysis, eating the entire of the fair use analysis. So
did John write this summary? I'm betting he did.
Yes. So
he always likes to hear me chime in on fair use.
Well, it's a good point.
Well, transformation. Yeah.
It's interesting that transformativeness argument really does sort of outweigh everything else in this factor, in this analysis.
You used a term in an earlier discussion that now I've forgotten what it was, but it would fit here. It's just sucked it right up.
It's sort of a superseding factor, isn't it? Yeah.
Yeah. And I mean, I don't know how transformative it is. I just think it's wrong that you have to pay to get the building codes.
Right.
Which,
exactly.
That's not a legal analysis there. They've got to make it fit into the framework.
How do you comply with the law if you can't see the law? It's Kafkaesque.
And I don't think the law has sufficient originality.
Agreed. And as soon as, and it's interesting that the court sort of flipped it on its head and said, as soon as you incorporate a standard into the law, it becomes factual.
Right.
The fact is that the standard is now part of the law, and what the standard says, I guess that's factual too. So I agree with that outcome. I'm not sure that's the right way to analyze it. Fourth factor, the effect on the market for the copyrighted work. This was sort of an equivocal point. The appellate court took a different view than the district court. District court had acknowledged that Upcodes was creating a substitute for the original work, but that ASTM might have other incentives to create technical standards, even if some are incorporated into law and become and essentially lose copyright protection because the public benefits are substantial. The appeals court said, no, the Upcode service is a complete substitute for the International Business Code and would likely affect the market detrimentally for ASTM, but factually they didn't really buy that. ASTM showed that a modest number of users were also known ASTM users. They didn't show that they received any cancellations. They noted that ASTM's 70% of revenue comes from sale of standards, but no statement of what percentage comes in when those are incorporated into law. So the court also looked at the public benefits of the infringement as part of the fourth factor. And they looked at the case in Georgia Remember we had that state of Georgia
Yeah, which
case?
was pretty much the same, very similar
Very
fact
similar facts.
patterns.
Yeah, exactly. Let me see. I have some side notes about that. Let's just see. Georgia versus Public Resource Inc. was a 2020 case. God, hard to believe it's that long ago, where the U.S. Supreme Court held that official annotations to statute are not copyrightable under the government edicts doctrine. This doesn't go quite that far, but here the public harms were unknown, but the economic harm, there wasn't enough information about that. The public benefit, access to the law would outweigh really any kind of measurement of damages or injury to the market here. That's sort of what the court seemed to be saying. So the preliminary injunction was affirmed, and there we are. So
yeah. And so here's what, if I was a plaintiff and attorney in these cases, something I would be adding to my discovery questions. Mm-hmm. Did you use a generative AI program to create any or all?
Oh, yeah.
Because I don't think there's enough originality. And two, do we really think there's going to be human authorship, a sufficient amount of human authorship going forward in these kinds of documents?
Remember, in this case, the 2018 standard was what was at issue.
Well, yeah, right. But
going forward, you would absolutely.
But going forward, I'm questioning,
especially if generative AI is a fair use of the underlying original material. So
we can argue out of both sides in the same podcast.
We're lawyers. That's our job. We're trained well at our respective law schools.
There we go. There we go.
Anyway, well, our next story is an interesting one. It's Tennessee. Development has been a long time coming in this creator economy. I think I've talked about this before in one context or another, where we have these influencer creators, whether it's Instagram or YouTube or whatever, that incorporate kids, the family's kids into the content. Well, Tennessee has now passed Senate Bill 1469, aimed at regulating family influencers, specifically protecting kids who appear in monetized social media content. The bill has cleared the legislature. It's on the governor's desk waiting for signature, which is expected, and it will take effect on July 1st of this year if it gets signed. And that will mean that Tennessee joins California in extending Coogan-style protections to the world of digital content creation. For those who aren't familiar with the Coogan law, California's Coogan Act is a longstanding law named after the child actor Jackie Coogan to protect kids' actors' income and wealth from being misused by parents and others. Basically, child performer protections say if a kid appears in film, TV show, commercial, a portion of their earnings has to be set aside in a protected account. Here in California, those are called a Coogan Trust account. But those laws were really built for the traditional Hollywood scenario and didn't apply or hadn't been applied clearly to YouTube family channels and TikTok creators and Instagram and those kinds of things, where Instagram-driven content that features kids are sort of central. So this is a big gap that had to be filled. Children appearing in lots of this monetized content, often daily without any clear legal framework, ensuring that they're compensated or protected. So SB 1469 is designed to close that gap. At a high level, it provides that if a minor is featured in content that generates revenue, that kid is entitled to a share of the income, and that share has to be preserved for the child. In other words, if the content is a business, the participation isn't just family life, it's child labor. And the law is starting to recognize that.
Yeah.
And we don't want to overstate it. This is not a full equivalent to the Coogan law, at least not yet. It's narrower. We don't have a body of case law or anything like that, but it's moving in that direction. So this is not just about Tennessee. Now, California has already also taken steps to update the Coogan law to address minors and social media content. Tennessee doing the same. I think we'll see other states stepping up as well. And pretty soon we'll have this patchwork of laws that might make things hard for us as lawyers, right?
Well, especially because clearly, I mean, I guess you would have to look to the state of residence.
Well, either state of residence or where the production is happening, or there could be a number of things, but it may also be that we end up sort of adjusting to the most restrictive state.
It could be. And then what's Yeah, what's going through my mind is, there are exceptions to child labor if you're
Hmm.
working on the family farm.
Yeah.
But let's say you're working on the family farm, but now you've become YouTube famous
Hmm.
with your everyday riding of the tractor or whatever it is.
Well,
I
it's
mean,
interesting. There's a lot of rhetoric in the in the creator economy about farming audience, farming viewers,
oh
right? We're
yeah,
planting
really?
seeds and we're nurturing them with content every day, and we're growing
Oh,
a crop
okay,
of
yeah.
followers. So it's not it's not an inapt way of
And
articulating it.
right, well, or I look at this was her kids were grown well before all
Yeah.
of a lot of social media, but the Pioneer Woman who's in Paul Husky, Oklahoma,
Hmm.
had her kids been younger. And then I was actually listening to an interview recently. I can't remember who it was,
Hmm.
but talking about allowing their yeah, Duck Dynasty.
Oh
Do
yeah.
you remember Duck
Sure. Sure.
Dynasty? Okay. So Sadie was one of the children when
Hmm.
that Duck Dynasty television show was on, and how she's made a decision to allow her children to be on social media
Yeah.
with her
Hmm.
because she feels the positives outweigh the negatives. So
Yeah.
that is a actual I think real life example of, where this would be a really great thing to make sure that
Yeah.
the kids are provided for. Not that I would think or know anything about
Yeah.
what they're doing, but
I think we talked about this back in the days when there were those family shows. What was it, John and Kate plus 8 on
yes, we
Discovery or
did.
something
What are
like
they
that.
doing
Yeah.
to
What are they doing to set aside money for the kids and protect them because the kids are doing work essentially. Same thing here
yeah.
now in this social influencer space. I think for us as lawyers, we need to be just thinking about this more as we advise the folks that are in this space. Ask the questions about, are there minors regularly appearing in the content? Is it monetized? Is it generating ad revenue, sponsorships, and so on? And then are we setting aside money for the kid in compliance with these laws and whatever new laws come in as well? Most
Yeah,
influencer
and I
brands
had
just
a
aren't designed for this yet.
right, and I had a great conversation with a family law attorney a couple of years ago, where the kid was an influencer
Mm-hmm.
and mom and dad got divorced.
Yeah.
Who's taking on the tax liability?
Mm-hmm. Mm-hmm.
Because that revenue it gets taxed to a parent. So I think there's more. Even you need to talk to your tax
Yeah.
advisor about all of this too, when you've got kids in social media.
And it may be reason for forming entities, loan out companies and things like that to protect all of the, to essentially be the repository for the income as well as the liabilities, the taxes, and so on. So that if there is a divorce or whatever, maybe in the case of a divorce, you spin off an entity to control whatever the kids are doing, to own whatever the kids are doing.
Yeah.
Lots of big questions here about estate planning as well. It's all kinds of stuff that comes into play here. The bottom line is, look, the creator economy is entertainment, so we as entertainment lawyers need to be thinking about this. And when there are kids involved, we need to take a look at the labor laws. We need to take a look at these Coogan-style laws, and pay attention. It's going to keep changing and keep evolving. I think it's a good thing in general. Let's protect the kids. It's so easy for kids to be exploited by their parents, and nobody even realizes it's exploitation.
Right.
So, and even, it's not out of any ill intent. It's just something we have to think about. You don't want to have kids that were famous on internet for their YouTube channels, and then they reach adulthood and there's no money for them, and they're not even the owner of the channel that they were famous on or whatever. So there's lots of components to this. So
yeah.
Well, that about does it for our content for the episode. As always, I want to say thank you to the audience, our loyal listeners, and our lawyer listeners for spending time with us. And again, invite you to leave us feedback. Go to entertainmentlawupdate.com, tag that little red flag and leave us a voice message, or send us an email, entertainmentlawupdate@gmail.com. Tamara, how do folks find you?
Yep. They can find me at harperbates.com, createprotect.com. On most social media, I'm at Tamara Bennett, TAMERABENNETT. And Gordon, happy anniversary again.
Happy anniversary
thank you for making this podcast happen.
Our podcast is
Um,
an adult in the eyes of the law at 18 years old now, or 17 years old. Sorry. So we got another year to go.
we have another year before it's fully grown.
Entering the adulthood phase, though.
That's right.
Yeah.
That's
Well,
right.
I'm Gordon Firemark from Los Angeles, California. You can find me at my website at firemark.com. Send me email, gfiremark@firemark.com. Most social media websites, gfiremark is my handle. And let's also say thank you to our team. We have John Janicek, our managing editor, Charles Thorne, Alexis Allen, and we have a new addition to the team coming next month. So that'll be exciting. And that's that. And if you are interested in joining the fun and being a part of the Crack Entertainment Law Update volunteer contributor team, reach out to us and let us know. Again, that email address is entertainmentlawupdate@gmail.com. And that's it for